Good morning and welcome to JEG Law Ltd. This morning we're going to discuss E-2 Non-Immigrant Treaty investor visas and status, which are granted only to citizens of countries that have entered into a bilateral investment treaty with the United States, which include the North American Free Trade Agreement and the Colombian American Free Trade Agreement, otherwise known as NAFTA and CAFTA. A treaty investor visa is granted to non-immigrants for the purposes of making a substantial investment in the United States. A substantial investment is also understood as a non-marginal investment of sufficient size to support more than the investor and his or her family within 2 to 5 years of being granted E-2 non-immigrant status, depending upon the size and nature of the investment. There is no number that defines substantial and non-marginal. E-2 investments can be much less than the $1 million or $500,000 sum that is required for immigrating through investment. Stateside processing of E-2 non-immigrant status can require an investment of less than $100,000. However, a U.S. consulate will generally apply stricter scrutiny over investments below $200,000. Treaty investor enterprises must be entrepreneurial in character, and the investor applies for a treaty investor visa in order to be admitted to and to remain within the United States so as to develop and direct his or her investment enterprise. Non-immigrant treaty investors must provide directly or indirectly employment for American workers. And American workers are defined as workers who permanently reside within the United States with an unrestricted right to work, such as U.S. citizens, lawful permanent residents, refugees, asylees, family unity beneficiaries, etc. The investor's spouse may apply for and be granted unrestricted right to work in the United States, unlike the investor, whose employment is solely to develop and direct the investment enterprise. Spouses and children are also granted E-2 status and have equal access to U.S. schools and educational institutions as U.S. citizens and permanent residents do. The treaty investor should have a controlling interest in the enterprise and can partner with U.S. citizens, permanent residents, or persons from non-treaty countries with an alternative lawful status in the United States. An interest below 50% usually means that the applicant does not have the required qualifying control over a smaller business, while more than 50% ownership clearly indicates qualifying control. Much larger investments, however, allow for under 50% ownership to constitute functional control. However, investments that are this large may also qualify for immigrant investment status where enough jobs are created. So keep that in mind. Employing U.S. workers as a non-immigrant treaty investor is a much simpler concern than job creation as an immigrant investor, because employing U.S. workers is a simpler requirement than creating jobs within the United States economy. A business plan with a regional market analysis is helpful to prove the viability of investment for the non-immigrant investor, but need not establish job creation within the regional, or national economy as required from immigrant investors. Moreover, there is no set number of jobs that must be created to measure the sufficiency of the investment enterprise that the treaty investor must develop and direct. An informal guideline is that at least 2 or 3 jobs must be created in the smallest viable treaty investment enterprise. As with investment-based immigration, funds must be irretrievably invested for non-immigrant investments as well, including those secured by personal assets, personal funds, and unencumbered personal assets, a mortgage with the alien's personal dwelling used as collateral, or some similar personal liability. A reasonable amount of cash held in a business bank account or similar fund to be used for routine business operations may be credited as investment capital. The E-2 investment must be close to the start of actual business operations, not simply in the stage of signing contracts, which can always be broken. Also, the non-immigrant E-2 investor must remember that uncommitted funds in a bank account do not require an active investment unless they are used in the routine operation of the business. An irrevocable escrow account may be created through the release of funds stipulated upon an E-2 treaty investor visa or status being granted, identifying capital reserves to be invested in a manner explained by a detailed business plan used to qualify the E-2 application. A non-immigrant treaty investor visa is granted for a 5-year period and permits admission into the United States as a non-immigrant treaty investor in 2-year intervals. Both the visa and the 2-year admission period can be extended indefinitely, so long as the investment enterprise remains in existence as a real company with continued business activity and employment of U.S. workers. A treaty investor need not have an unabandoned foreign residence, and ordinarily need only have an unequivocal intent to return to his or her country of nationality any time in the future, while their enterprise remains intact or immediately after ceasing business activity. In other words, immediately after closing business. Moreover, the nationality of a spouse or child of an E-2 treaty investor is not material to the family member's classification. E-2 treaty investors can be accompanied by E-2 employees whose duties are executive, managerial, or supervisory in character, or who possess special expertise that is essential to the firm's operation in the United States, such as a degree of proven expertise, uniqueness of specific skills, and length of experience with the firm and its operations. The presence of E-2 employees must be considered as a period to train similar U.S. workers, and their salaries should reflect their value to the investment enterprise. Keeping the principles that I have discussed in mind, investors seeking to relocate to the United States should seriously consider the E-2 investor visa as an accessible and durable non-immigrant visa classification to be followed by immigrant processing once your investment is established. Thank you for joining me during my presentation. The next video that I'll be sharing with you deals with E-1 treaty trader visas and status.